Hello and welcome back to my channel. It feels so good to be back to you today. We're quickly going to go over the little things that I missed while I've been away dealing with my stuff. But when I tell you, it feels so good to be back here today with you. How does that saying go? It's a new day, it's a new world, and I'm feeling good. Dun, 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 dun. Okay, that's all. I'll save you. That's all I'm going to sing to you. But if you're ready, I'm ready. Let's get into it and dive in real quick. Now, I'm just going to do a really quick summary of everything that was missed in the last couple days, or I guess since last week. Let's make this quick because we have some motions to get to, okay? And I don't want to toot my own horn here. Toot, toot. I do, and say that I was right, but when you're right, you're right. And when you see through BS, you see through BS, and you can call it from a mile away. When the B613 was hired on Blake's team, I made a video and I was like, wait, because in the next few weeks, they're going to come out with a whole bunch of PR stunts. They're going to try to do some volunteering and help in the community and share their time. And Blake's going to try to turn her image into a trad wife 2025. And just wait, because they're going to roll out a bunch of PR stunts in order to make you think that they're really giving and they give back to the community and they help out. And what happens? Blake Lively woke up at 5 a.m. to make donuts with Chopped winner Hugh Mangum. Oh, that's kind of like my last name, Magnan, but not. We all saw it, and I think we all saw through the BS. I mean, this was like such a PR stunt, whether it worked in her favor or not. I don't know, girl, just stop. We're tired. No one's buying it, okay? No one's buying this whole, oh, I like to give back and let me volunteer my time. If you want to go out with your family, great. If you want to bring your kids out, great. No one's telling you to stop living your life, okay? Do it. But all these PR little gimmicks, it's gross, okay? No one's buying it. It's really just, it's a PR stunt, and we all saw through it. And funny enough, this comes at the week where a lot of larger social media content creators picked up on the story about Deadpool and Wolverine and how Ryan, literally in his own admission, which I covered back in January, says that he put his child in Deadpool and Wolverine to say some very distasteful things. The child actor their child didn't want to do it at first, said that she didn't want to do it, and he like kind of pressured her and was like, fine, if you don't want to do it, I'll get someone else. And then they were like, no, I'll do it. And in their own admission, behind the scenes, if you watch my series on the Deadpool and Wolverine, all the little Easter eggs, they say they made that child say a variation of like 500 sayings. They made her do it 500 times and she didn't even want to. So coming off the back of that, and then coming off the back of Justin being spotted with that fresh hair don't care, Blake does this. Blake goes out and makes donuts. And it's not completely out of my mind that donuts, I mean, everything is intentional with these people. Because you cannot tell me that it was not intentional to go to a donut shop versus cake or a bakery or anything. It was donuts. And in Deadpool and Wolverine, they drag Nicepool's body behind a donut cart. And there's reference to donuts. So I don't know what this means, but I know that it's definitely an Easter egg. It definitely seems that they're still trying to jab one into Justin Baldoni and or, get something over us. But this will be found out because it seems a little bit trickery and exactly in the realm of Ryan Reynolds and Blake Lively and what they've been doing for decades. Ooh, and what do we have here? Is this a little sexual harassment on the set of A Simple Favor from Blake Lively? It sure is. It sure is. There is some behind the scenes footage, a little interview with the director, Paul Feig, and Blake Lively. And I have to ask, what the fig is going on here? Okay, because Blake Lively's character grabs her co-star by the kazunas, grabs him and admits to improving it. And not because it was kind of written in the scene, or there was a moment in the scene where there was some, any kind of thing going on that would make her want to do this. She said it's because she felt like it was something her character would do. But this action, improved. No intimacy coordinator needed. No rehearsals. No. An improv nut grab? Holy camole. This being one of Henry Golding's first roles. And yeah, Blake Lively just, I guess, improved grabbing him during one of the takes, and that was the take that they used. And during the behind the scenes footage of the interview between Paul Feig and Blake Lively, they're laughing about it. It was hilarious. But don't you worry, because in good fashion, Blake's team has replied. A spokesperson for the actress stated that this scene was pre-planned and agreed upon, contrasting it with Justin Baldoni's alleged actions. A spokesperson for Blake Lively told Page Six the scene was pre-planned and the cast discussed the creative suggestion before it was filmed. Blake collaborated and reached an agreement with the director and her co-star before filming the scene. That is the entire point here, and that is what Mr. Baldoni did not do, they said. The audio commentary reference clearly says that she made a creative suggestion, all agreed on it, and it was incorporated through the appropriate filmmaking process. Well, then that's not really improv in the scene, is it there, Blakesky? The representative contrasted Blake's creative suggestion to how Justin Baldoni treated her on set, claiming he overstepped his boundaries and performed intimate actions that were not in the script and had not been previously discussed with her. Justin decided on his own without asking first that it was okay for him to bite and suck on Blake's lower lip. Girl, don't make me pull up the video of you sucking on that man's lip. Don't make me pull up the video of you sucking on that man's lip, because I will do it. Okay? Again, without advance notice or asking for consent during a scene in which he continued to improvise more kissing on each take. Well, we shall see, because we now know that everything was caught in 4K, and Justin Baldoni and the Wayfair parties are very adamant that they have Blake Lively improvising intimate scenes on tape. Her doing it. Okay, so this is just one example of the many in Blake's lawsuit against Mr. Baldoni. The attempts to smear Blake have now come so full circle that they are even starting to prove her own point. Oh my God. Oh my God. You can't be thinking that this is a part of the smear campaign, okay? Gah. So there you have it. She didn't just improvise it like she said when she was doing the behind the scenes interview and all laughing about how she just felt like doing it because it was something her character would do. In that film, I believe she smacks Anna Kendrick as well in the butt, and that was also improvised. Okay? And she's talked about that before, how that was an improvised thing, her hitting her. So it just seems like her suggesting these sexual inappropriate actions that are not even needed with the director and them approving it is somehow completely different than the actual director of the movie who's filming in it, taking notes from an intimacy coordinator and working through them with you. Also, in the dance montage, they do talk about what's happening in the scene. It's on video, Blake. Anyway, that just seems a little bit. There was an answer for everything. To me personally, it just seems like Blake is able to do whatever she wants. I don't know, it's just all very strange. It's all very weird. Because, Justin is the director of It Ends With Us. No matter how you try to spin it, Blake, and you try to act like you're the filmmaker of that film, you were not. And everything that happened in the scene so far are in the scope of the characters that are actually in the scenes. So, I don't know. This is not a good look. It's not a good look, okay? And if there's one thing that Blake Lively and Ryan Reynolds are going to do, it's always tell on themselves. And this is just one more example of them telling on themselves. Literally saying that she improv'd grabbing him and laughing about it. How cute. I just think no matter whose side you're on right now, whether it be the Wayfarer parties or Blake Lively and Ryan Reynolds parties, regardless, you need to be on the side of truth and justice and what is right and what is wrong. And it just seems, and I truly believe this through reading all of the lawsuits and Blake's lawsuits and amended lawsuits, there's nothing there to insinuate any kind of ongoing, repeated sexual harassment that could be severe enough and or perverse enough in nature, objectively and subjectively, that changed her employment. I just don't understand it, because even after the meeting, January 4th, she keeps bringing up how she had that all hands meeting. Even though it was a sabotage, she literally just sent a text being like, hey, I'd like to get together before we meet, and tried to get Justin to just do it by himself. Everyone went. We all know that story. The next day, she had her kids on set. You have this meeting, and then the next day, you're so unsafe on set that the next day you're able to bring your kids on set. And not only did she bring her kids on set, but apparently they set up a booth to try to get donations from the crew for, I think it was Kids and Horses or something. What? So you're okay to have your family on set, but now you're saying that the misconduct was so severe that you brought it up in the spring of 2023. Then you brought it up again on November 9th. And then you brought it again on January, even though from November to January, she wasn't on set. No filming had occurred. So nothing changed. So then on January 4th, you have the all hands meeting. And then the next day, you're so confident that your kids are on set and you're texting Justin Baldoni to come into your trailer to pump. That was the next day. The next day, you're telling him to come into your trailer to pump. But you felt so unsafe because of the misconduct, the repeated misconduct that you brought it up. I'm going to keep saying it because make it make sense. May 2023, you bring up a few concerns after being off for a week, sick. You bring up these concerns. They address them. And then in November, you bring that 17-point return to work, which we might add that up until that point, Blake had only been on set for 16 days. And not one scene with nudity and or intimacy, except one, I think it was a kissing scene, one kissing scene that she directed, had been done. So that whole 17-point demand, they weren't even shooting any of that stuff yet. And then you wait, you push your filming back. You're supposed to go on set mid-November. You push it to December. Then you push it to January. Then you have the meeting in January with the same return to work. So you must have been so worried about the repeated misconduct that you pushed your filming from November to January. You have the meeting in January. And the next day, you have your kids on set? You're inviting this man into your trailer? Come on. Okay. Thank you for tuning into my rant and TED Talk. Let's get into it because there are two memorandums of law in opposition. One motion was filed to dismiss the amended complaint filed by Ryan Reynolds, and one was for Jed Wallace, and we're going to get into both of them right now. I've read through both memorandums, and we're just going to go over the highlighted parts, but I will bring it up on the screen so y'all can check it out for yourself. What was that? So y'all remember how Ryan Reynolds tried to get himself dismissed from the case along with Blake Lively, which honestly is just laughable, but of course, do what you gotta do. Well, Brian Freeman and the Wayfair parties have come back with a memorandum of points to throw that dismissal kind of out the window. I do think this is super well written. One of the biggest things I think in this case and what they're trying to do is figure out where it's going to be tried, if it's going to be California law and New York law. I'll go through a few examples as we read through this motion because it is super important, and I think that is going to definitely change a lot of things in this case. I think Judge Lehman has a big job ahead of him to figure out exactly where it's going to be tried. I thought this was, super well written. Great job. But it just goes to prove that, Ryan, you're in this thing. So straight away, it starts out with a quote from Ryan Reynolds himself. Remember how in Ryan Reynolds's motion to dismiss, he added immediately quotes from Justin Baldoni's 2017 TED Talk? Well, they did the same thing here. Memorandums of Points and Authorities Introduction. I've realized that I'm too big to fail at this point, so I just crush my enemies and drink their blood. Ryan Reynolds in an interview in July 12th, 2024. I believe this was an interview he was doing with Hugh Jackman, and he was saying how he always wanted to work with Hugh and how he always looked up to him, but now he's much bigger to him. And yeah, he's realized that he's too big to fail. And yeah, I don't know. It's going to be a weird thing because for me, I think Ryan Reynolds completed a lot of the things that he said was, I'm just joking. It was a joke. It was a joke. But if everything is a joke, then how do we know when to take you seriously? Was the SNL thing a joke? Was the nice pool thing a joke? Was this a joke? Was making fun of the intimacy coordinator a joke? There's just too many jokes, And if you're making jokes about it, then so can everyone else, I guess, That's enough of my commentary for now. Let's just get right into it. So the Wayfair parties have pleaded defamation and tortious interference claims against Reynolds sufficient to defeat dismissal. This is particularly true where, as here, Reynolds has superior knowledge of the facts underlying the Wayfair parties' claims, given the early stage of discovery. In the alternative, any defects or inartful pleading in the AFC is the amended lawsuit with the timeline of relevant events. The AFC, that's what they're calling it for the Wayfair party, just so we know, because they say AFC in here a lot, can be remedied by amendment, which is freely allowed. And the Wayfair parties have gained additional information to plead further facts to support each of their claims against Reynolds, as well as the need to apply California law. Furthermore, the Wayfair parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. A lot of what we're going to see in this motion is them saying, okay, if you do approve Ryan Reynolds' motion to dismiss, then can you do it so that we can refile and re-add the things that we need to add and also incorporate, because what they're trying to do is get Exhibit A stricken and not be able to use it. I think Leslie Sloan has brought that up. The New York Times has brought that up. And what they're saying is, well, we can take whatever we put into Exhibit A and put it into the body of complaint. That's fine. But please, if you are going to dismiss, allow us at least to re-amend the complaint. I think it's too soon for any of the parties to get dismissed, but that's just my opinion. An actual conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly. The laws of New York and California conflict as to each of the Wayfair parties' claims against Reynolds for defamation. false light, invasion of privacy, tortious interference, and civil extortion. As to false light and civil extortion, the conflict between the two states' laws is total. California recognizes the claims, while New York does not. The laws of New York and California also conflict with respect to defamation. California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. As New York and California laws conflict, the court must determine which law to apply to each claim. So that's going to be a big thing when it gets ruled as to what laws they are fighting. The interest of a state in a defamation action is significant and incontrovertible, where the plaintiffs are citizens of that state and live and conduct their business there. Though New York may have some interest in this action because Reynolds resides in New York, California has a much more significant interest because nearly all of the plaintiffs are residents of California or have their principal place of business there. The two corporate plaintiffs, Wayfair Studios LLC and It Ends With Us Movie LLC, are both incorporated and or have principal place of business in California. The plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were felt in California. It is purportedly based on reporting relating to Lively's complaint filed with California's Civil Rights Department, which asserts claims for violations of California's law. Reynolds' contention that the FAC fails to identify defamatory statements he made fails on its face. The federal rules require that each pleading be specific enough to afford the defendant sufficient notice of the communications complained to enable him to defend himself. Reynolds must have confused the rules of pleading with the rules of evidence. The FAC alleges that at least twice Reynolds stated to WME executives, Baldoni's and Wayfair's talent agency, that Baldoni is a sexual predator and that by implication, WME was in business with a sexual predator. The first statement was on July 15th, 2024, when Reynolds contacted Baldoni's agent, Danny Greenberg. We got names. Okay, we got names. He contacted not his agent. He went out of his way, allegedly, to contact Justin Baldoni's agent, Danny Greenberg, for the purpose of making these defamatory statements. On the call, Reynolds referred to Baldoni as a deranged predator and warned Greenberg that Baldoni should not attend the film's premiere the next month because no one wants him there. The second statement was on July 22nd, 2024 at the Deadpool and Wolverine premiere, when Reynolds told a senior WME executive that by representing Baldoni, WME was doing a business with a sexual predator. As alleged, Reynolds was pressuring and later demanded WME to cut ties with Baldoni. This is bad because deranged predator, not good. Not good. Sexual predator, not good. Those are not good. Lip gloss time. These allegations are more than sufficiently specific, identifying the speaker, the listeners, and why, where, and when the statements were made. Given the specificity, it is unclear why Reynolds cites cases involving allegations so threadbare as to admit the time, place, speaker, or listener. So remember in Ryan Reynolds' claim, he said, how is he supposed to even defend himself? He doesn't even know when this happened or who this was going on. It's so vague. Well, now you know, okay? Here are the 7 Wayfair parties well below the ceiling of the small group exception, and Reynolds defamed them all. Yeah, okay. Reynolds' defamatory statements are not unactionable opinion. Under California law, to constitute defamation, the offensive publication must state facts rather than opinion. And that seems like it stated some facts there, you know? Reynolds' attempt to recast his statements as opinion is believed by context. These statements were statements that at least implied undisclosed facts. All are susceptible to a defamatory meaning, namely that Baldoni had committed egregious sexual offenses that warrant the label of sexual predator. Being wrongfully branded as a sexual predator is defamatory as one of the most loathsome labels in society. Context also matters. Reynolds made the statements to a key WME figures in an effort to force WME to drop Baldoni. Reynolds' argument that his deep disdain for Baldoni precludes a defamatory meaning to his words is illogical. Yeah, I think so too. Reynolds' defamatory statements are not substantially true. Reynolds argues the defamation claim fails because his alleged statements are substantially true. But truth is a question of fact for the jury. Damn. Let me read that one more time because that's pretty good. Reynolds argues the defamation claim fails because his alleged statements are substantially true. But truth is a question of fact for the jury. Not for you, Mr. Ryan Reynolds. Taking the allegations in the FAC as true, as the court must on this motion, the court cannot conclude as a matter of law that Baldoni is 1, a sexual predator, or 2, that the Wayfarer party smeared Lively to retaliate for her disclosure of supposed misconduct. These propositions are expressly denied in the FAC with proof. Reynolds' statements have a different effect on the mind of the reader or listener from that which the pleaded truth would have produced. Reynolds' first argument collapses upon any scrutiny of the FAC. Reynolds points to 1, a conversation Baldoni had with Lively at Sony's discretion about her wardrobe choices. 2, a suggestion from the film's intimacy coordinator relayed to Lively by Baldoni, as Lively would not meet her, about the mechanics of a particular intimate scene, calling a costume sexy, hiring a Shakespearean-trained actor with an MFA in acting to play a doctor, Jamie Heath, not Baldoni, showing Lively in preparation for a birth scene, a single clip from a home birthing video depicting Heath's newborn son, and Baldoni perpetrated failure to deny biting and sucking at Lively's lip. Even construed in the most uncharitable light, which would be inappropriate here, these admissions do not show Baldoni is a sexual predator. That's so true, man. Okay, so what they're arguing, I mean, if you look over the things that they are arguing, him using the word sexy, I mean, the way that they explained he brought in a friend to play the OBGYN, which is like one thing that I am so hung up on because this guy is a trained actor. I mean, all of the things that they're claiming, the biting and sucking on the lip, don't even get me started because there is literal footage, I've played it, of Blake actually being the one to do that to Justin. Okay, so even with what they're claiming, it still doesn't make him a sexual predator or a deranged predator. And let's not forget WME still reps P. Diddy. Okay, okay. Reynolds' second argument is barred as it requires the court to consider extrinsic evidence not properly before it on a Rule 12b motion to prove that Baldoni is a sexual predator. Reynolds draws on excerpts from Baldoni's book, YouTube videos, and podcast episodes, none of which are in the FAC. Right, so you're bringing up all of these things from his past that have no bearing actually on what is in the lawsuit. By the extrinsic evidence, why can't I say that word? By the extrinsic evidence Reynolds relies on was not incorporated into the FAC or integral to it. The defamation claim against Reynolds has nothing to do with Baldoni's book or other extrinsic materials Reynolds raises. Reynolds also argues that the Wayfarer party's defamation claim fails for failure to plead special damages. But plaintiffs need not plead such damages where the statements of defamatory per se. With such statements, damage to plaintiffs' reputation is conclusively presumed, and he need not introduce any evidence of actual damages. As to the statements concerning Baldoni being a sexual predator, there is no question that these are defamatory per se. Perhaps the clearest example of libel per se is an accusation of crime. Reynolds' statements about Baldoni being a sexual predator is tantamount to a charge of serious criminality. Reynolds' statement about the other Wayfarer parties are also defamatory per se. The crew of the accusations is that the Wayfarer parties engaged in and or condoned sexual misconduct and took revenge on the victim of such misconduct. These allegations tend to expose the Wayfarer parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them to the minds of the right-thinking persons. Yeah. The Wayfarer parties have pleaded actual malice. Under the Constitution, a public figure pleading defamation must prove by clear and convincing evidence that the statement was made with actual malice. Reynolds was intimately involved in and integral to Lively's concerted campaign of extortion to extract concessions and creative control over the film. Reynolds and Lively's exploited Lively's false insinuations to coerce the Wayfarer parties to cede to them power and authority to which they were not entitled. Reynolds was also directly involved in the marginalization of Baldoni from the rest of the cast and exclusion from the premiere. Having yielded under duress to their coercion, Wayfarer finally resisted Lively Reynolds' demand that they take the fall for Lively's disastrous promotional campaign. Then Reynolds and Lively pushed falsehoods from production with a lie combined with an untraceable smear campaign to the New York Times. Reynolds and Lively, along with the Sloan parties, engaged in a coordinated effort to exaggerate benign interactions in service of a false narrative that Lively had been sexually harassed. They did so to instill terror in the Wayfarer parties and leverage it to accumulate power. This accumulation of power depended upon the ability to conjure and exploit ruinous allegations. The allegations were never true, and Reynolds knew full well or did not care whether they were true. Reynolds' insistence, he believed his words, although not alleged in the FAC and thus not properly before the court in an argument that he committed extortion, not defamation. Reynolds also knew that the smear campaign narrative was false or acted with reckless disregard for its truth. Along with its co-conspirators, Reynolds got a hold of communications between the Wayfarer parties from Stephanie Jones that disproved the claim that Wayfarer parties had orchestrated a smear campaign. Given that they had these materials, Reynolds, Lively, and the Sloan parties either knew that the narrative they later publicized was false or at best disregarded evidence. It also would have been clear to Reynolds, who owns a marketing company, that the cause of Lively's bad press was her decision to hawk liquor and hair care products while promoting a film about domestic violence. Thank you. If anyone should be suing anyone here, I'm pretty sure the people that should be suing are freaking Blake Lively, should be suing Ryan Reynolds, and should be suing Maximum Effort for making her, like, that whole PR. Girl, you're placing blame on the wrong people. You and Ryan need to look in the mirror because y'all did that yourselves. And Blake, if you want to sue anyone, you should be suing your husband, okay? We all know that to be true. Finally, while the FAC satisfies the Wayfarer party's pleading burden under an actual malice standard, it is important to note that 6 of 7 Wayfarer parties are not public figures. Heath, Sarowitz, Abel, Nathan, and it ends with us and Wayfair. The Wayfair parties have adequately pleaded a claim for civil extortion. The court is unaware of any case holding that there must be a threat of litigation in order to state a plausible claim for civil extortion. Reynolds further claims that he cannot have engaged in extortion because he did not obtain property from the Wayfair parties by means of threats. But California law proscribes extortion, notwithstanding that the defendant ultimately obtained no money or property by means of his extortionate threats. Here, the Wayfair parties have alleged facts sufficient to state a claim for civil extortion based on, at least on the demand that Reynolds and Lively, that the Wayfair parties issue a self-destructive statement taking blame for Lively's press woos, or else the gloves would come off, and they would attack Wayfair in the press. Guess what? The gloves did come off, An overlap in the claims for false light and defamation is not a reason to dismiss the false light claim. It just means the claims will likely rise or fall together before the jury. To the extent that there exists any defects in the Wayfair party's false light claim, the defects can readily be cured by an amendment. And we're almost there. I think this is one of the most interesting parts because Ryan did say, how was I supposed to know that telling WME that he's a deranged predator or a sexual predator would do anything? I don't know. He just has a contract, man. I mean, that's not, you know what I mean. That's what he was kind of saying, saying. He was saying, I didn't know. I didn't know that was going to end his contract. Yeah, okay. Because the FAC pleads a claim against Reynolds for his tortious interference with Wayfair and Baldoni's relationship with WME. Lively, Wayfair, and Baldoni, the FAC alleges that Reynolds approached Baldoni's agent, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, a phrase that uncoincidentally later appears in the press, and at a later date demanded that the agent drop Baldoni. The FAC further alleges that Reynolds and Lively, who are two of the most powerful stars in the world, demanded through their talent agency, which also represented Wayfair and Baldoni, that the Wayfair parties publicly apologize for so-called mistakes during production, or else the gloves would come off. Basically, I know you're probably tired of hearing me talk about it. They just go over why it should be held in California and not New York. Ryan Reynolds is suggesting that New York choice of law principles are helped, but they obviously want California because there's just different laws, And then also they go into the contract of WME, which is what I want to get into lastly, because they are claiming tortious interference. So we'll just go over that quickly. So it doesn't make sense that what they're alleging, the Wayfair parties, is it doesn't make sense to use the New York law versus the California law because the Wayfair's contract with WME was based in California. So were all of the prospective economic advantages that they would have got or suffered due to this issue. Okay. Tortious interference is a tort independent from defamation. Reynolds contains that under New York law, tortious interference is duplicative of defamation, where the entire injury complained or by plaintiff flows from the effect of his reputation. First, Reynolds ignores the fact that the courts applying California law do not treat such claims as duplicative and indeed routinely recognize defamation as an independent wrongful act in claim for intentional interference with prospective economic advantage. Second, where a plaintiff plausibly alleges that its economic harm was not directly and solely caused by generalized damages to reputation. The FAC states a claim for intentional interference with contract. Under California law, the tortious interference with contractual relations require 1. The existence of a valid contract between the plaintiff and a third party. 2. The defendant's knowledge of that contract. 3. The defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. 4. Actual breach or disruption of the contractual relationship. 5. Resulting in damages. Let's get into it. Reynolds claims that the elements under California and New York law are the same. Reynolds then materially relies on this misleading misstatement of the law to argue without citation to authority. Cessation of performance is not the same thing as breach of contract, but causing a third party to cease performance is the same thing as disruption of a contractual relationship, which meets the California standard. Reynolds' other argument that the specific details of the contracts with WME are not sufficiently described and that Reynolds' knowledge of these contracts is alleged only in general terms are easily curable issues which the Wayfarer parties should be permitted to address by repleading. Reynolds himself is alleged to be a client of WME in the context of an industry in which WME represents many prominent film actors and directors on identical or nearly identical terms. By procuring engagement for them and receiving commissions as a percentage of earnings, give rise to the interference that Reynolds, one of the most successful actors, understands the contractual terms by which talent agencies and specifically WME are bound. Further, contrary to Reynolds' disingenuous argument, the FAC clearly identifies Baldoni and Wayfarer as the Wayfarer parties who were represented by WME. So basically, Ryan Reynolds was trying to say, how am I supposed to know about the contract? I don't know anything about the contract. It's so vague. How was I? Because you signed one, bro. You and your wife. You are with the same agency. So you know what that contract was? Reynolds' attempt to downplay his defamatory statements that Baldoni was a sexual predator and that WME was working with the sexual predator is merely insulting and therefore not wrongful means. As discussed above, his statements plainly were defamation per se. Reynolds also ignores the threats made to WME that the gloves would come off if the Wayfarer parties did not take the blame for the blunders of Reynolds and Lively's threats they carried out by defaming WME's clients, harming the Wayfarer parties and WME. Alternatively, the FAC states a claim for intentional interference with prospective economic advantage. Reynolds attempts to invoke the privilege of economic self-interest, an exception to the international interference with prospective economic advantage, by suggesting that his alleged motive to seize control of the film's production proves he did not act solely out of malice. But that phrase, which reads in its entirety, the defendant acted solely out of malice or used dishonest, unfair, improper means, is not a requirement of California law. Reynolds does not claim that he and Baldoni were actors competing for a role and that his conduct was intended to cause WME to procure the opportunity for him instead of Baldoni. His defamatory statements and threats were intended to accomplish what they did in fact accomplish, that WME would drop the Wayfarer parties from representation. Alternatively, the FAC states a claim for negligent interference with prospective economic advantage. As a further alternative, to the extent that Reynolds' intent was not sufficiently alleged, the cause of action for negligent interference with prospective economic advantages survives under California law. However, although the FAC does not directly address this legal issue, there are facts pled which may give rise to a duty of care, such as the fact that Reynolds' promotion company Maximum Effort was hired to promote the film. Hello? As an agent, Reynolds may be under a duty not to recklessly damage the film's director, lead actor, and studio in the eyes of the public or their talent agency. The agreement between plaintiffs and defendants created a duty of care. Because a duty of care may arise here, at a minimum, the Wayfarer party should be permitted an opportunity to replead the existence of a duty of care. Wow. So what they're saying here is that like Ryan Reynolds, we all know this, like he's involved, right? But he was actually hired by the studio. He was hired by Wayfarer. So there was an underlying contract of duty of care. And since he was hired, he was an agent working for the film. He had a duty to not recklessly damage the film's director, lead actor, and studio in the eyes of the public or their talent agency, which he did. Oh my gosh. Reynolds is liable for his direct actions as well as by conspiracy. The Wayfarer parties have pleaded ample allegations in connection with each cause of action against Reynolds to support the existence of a conspiracy as the pleading stage. For example, the FAC alleges that Reynolds and Lively made a joint threat to attack the Wayfarer parties in the press unless they immediately issued a self-immolating press statement. The Wayfarer parties have also pleaded facts that established each claim against Reynolds based on its own direct acts. Finally, even if there exists some technical defects in the conspiracy allegations, the Wayfarer parties should be granted leave to amend. Attorney fees are not available to Reynolds under Second Circuit law. Man, get out of here with these freaking attorney fees, please. Y'all started this in the first place. Even if the court grants the motion in its entirety without leave to amend, which would be wild. I do not see that happening. Maybe depending on where they decide to, what law they decide to use, California, New York, could Reynolds get off a few of the things? Yes. Is his entire thing going to be dismissed? I don't think so. But what they're saying is that even if it is, man, they aren't paying any of those freaking lawyer fees, okay? Well, wowzers, that was a mouthful, but pretty much they're just saying he knew exactly what he was doing. It's not like he just went and said an opinion. He sought out these agents at WME, and by even calling him a deranged predator or a sexual predator, you knew exactly what you're doing, and you can't say that you don't know what the contract is when, like, legit you have a contract with them. Doesn't make sense. So we're going to see probably in the next couple of days. I think they're also going to have a response to Blake Lively's motion to dismiss. That will be an interesting read. But right now, Lively's team, as of this morning, filed a memorandum to Jed Wallace. Jed Wallace came out, I think it was just a week or two ago, and filed a motion to dismiss his claim. He also came out with his own statement saying that, like, yo, I'm willing to say this on the record. I did not do any of this stuff. And this is Lively's response to him. So this all has to do with Jed Wallace and a memorandum of law in opposition to Jed Wallace and Street Relations trying to get their case dismissed. I'm really just going to brush over the main points because it does repeat a lot of the same stuff, and it's really just about this smear campaign and how they orchestrated a plan against Blake Lively. Again, I do see where she's coming from if she was just isolated and reading the text messages that she received from Stephanie motherfucking Jones, who gave those to Leslie Sloan, that you could see that. But again, there is a lot of text about planning, but there's not any evidence about execution. But we will read just a few statements from this memorandum. This was filed this morning. Jed Wallace and his company, Street Relations Inc., and together with Mr. Wallace, the Wallace parties were the covert operatives in Justin Baldoni, Jamie Heath, and Steve Sarowitz's conspiracy to retaliate against plaintiff Blake Lively for speaking out about Mr. Baldoni and Mr. Heath's misconduct on the set of It Ends With Us. Mr. Wallace is a self-described hired gun who executes untraceable campaigns on social media platforms. In this case, despite Mr. Wallace's boasts about his clandestine abilities, he and his company got caught. Even without discovery, the facts available to Miss Lively already show that Mr. Wallace and Street Relations joined and actively participated in the conspiracy to bury Miss Lively and destroy her reputation in retaliation for speaking up about sexual harassment. Their co-defendants' own text messages and emails, including with Mr. Wallace, confirm that the Wallace parties knowingly joined a conspiracy designed to harm Miss Lively, knew what the conspiracy was trying to accomplish, and helped that happen. The other co-conspirators could barely contain their glee at how successfully the Wallace parties executed the plan, patting themselves on the back about their amazing work. Defendants Melissa Nathan and Jennifer Abel celebrated the conspiracy's total success in achieving a shift on social media, due largely to Jed and his team's effort to shift the narrative towards shining a spotlight on Blake and Ryan, instead of on Mr. Baldoni and Mr. Heath's misconduct. What's so crazy to me is that like nobody was even talking about misconduct on set. Neither was Blake. So it's just like all very confusing. This smear campaign is all very confusing because Blake Lively also hired her own crisis management PR at this time. Justin Baldoni did too. Like, aren't PR people supposed to be always putting good things about you in the press? It just seems like one person won and one person lost. Like, I don't know. I honestly, in my heart of hearts, do not believe the smear campaign. I do believe that they were trying to make sure that Justin's voice and his message were coming across, and that monitoring to make sure that Blake's team and people from Blake's parties, including Leslie Sloan, who admittedly, like, there are texts from her too where she was feeding bad press about Justin Baldoni. So both camps, I don't know, glass houses, right? First, the Wallace parties argue that they are not subject to personal jurisdiction in this court. First, the Wallace parties argue that they are not subject to personal jurisdiction in this court, but their sole argument against Miss Lively's theory of personal jurisdiction, a conspiracy-based theory, is that the Wallace parties did not join any conspiracy. To be clear, the Wallace parties do not dispute that a conspiracy existed, or that other members of that conspiracy established sufficient contacts with the New York. So basically, in this entire complaint, they just, again, Mr. Wallace was trying to have his case be placed in Texas because that's where he does his business. They're trying to say, hey, this guy can come here. It's not a big deal. He takes trips to New York all the time. They're also saying that he made a declaration saying that, which he is willing to testify about, that he was not hired to smear anyone or put out false stories except to research social media trends and track all of the stuff happening online and then report that back to the Wayfarer parties. And they're saying that that was like a self-serving declaration, and pretty much that it's too early for him to get dismissed. Yeah, that's just like a summary. There were a couple interesting things though, which I will read from here. Miss Lively's claims against the Wallace parties, like her claims against their co-defendants, ultimately trace back to Mr. Baldoni and Mr. Heath's harassing and inappropriate behavior on the set of the film. Miss Lively raised complaints about that conduct to Mr. Baldoni, Mr. Heath, and others as early as spring of 2023. She later reiterated those same concerns and others, negotiated a contract writer through which It Ends With Us Movies LLC agreed to 17 protections for the film's return for productions, and as agreed to in those protections, reiterated those concerns again to Mr. Baldoni and Mr. Heath at the January 4th all-hands meeting. Right, you just keep reiterating the same things over and over and over, but you're not actually proving that any misconduct was done, and you never went back to set during all of this times. You just keep bringing it up, it's just very interesting. But also what they don't say is what happened on January 5th. She texted Justin to go to her trailer while she was prumping, and also she had her kids on set the very next day. Those protections included prohibitions on spontaneous improvisation of intimate and sexual physical touching, simulated sex, or nudity. And to be clear, up until that point, none of those things were shot yet with Blake Lively. That is something very important that everybody needs to know, is nothing was shot yet that had simulated sex, physical touching, or nudity up until the point, okay? So what they're just saying is, let's just read it. As the film's August 6th, 2024 New York premiere neared, Mr. Baldoni and Mr. Heath grew concerned that their misconduct would become public. And in a blatant act of retaliation against Miss Lively for bringing her concerns about that misconduct through appropriate professional channels, engaged in a coordinated campaign to destroy her reputation, distract from their own behavior with false narratives about Miss Lively, and get her way with their misconduct. What appropriate professional channels? Where are the complaints? Where are the reports? I want actual documents. I want actual reports that you reported. Actual complaints of report. Together, the conspiracy set out to destroy Miss Lively and punish her for having the courage to come forward about the harassment she and others experienced on the set of the film. But you kept shooting. You didn't officially make a complaint. You didn't bring your lawyers. You didn't talk to your agent. You didn't bring in your reps. You didn't call the union. Where are the official complaints and reports? You allowed this deranged predator, this sexual predator, to continue filming. And if everything would have went well, if your hair care line and your alcohol company would have taken off and your reputation would have succeeded, you still to this day wouldn't have said anything. And that is my biggest problem here, because when you see something, say something. You don't stand by the sidelines and hope that as long as you get away with looking good and making money and being the successful princess of America, that he can go on to other movies with other actresses. Don't get me started. The courage to come forward. My gosh. They just go on to explain how they believe that they planted stories about weaponizing feminism, which is like, those stories weren't planted. We have been saying that Blake Lively has weaponized the Me Too movement and has weaponized feminism against them. That is not Justin Baldoni saying that, okay? There is no smear campaign there. Everyone can see it for themselves. They go into a few examples here of text messages that they received between Melissa Nathan, Jennifer Abel, and Jed Wallace about how, Justin said that he doesn't feel the same protection. And they tell him like, well, we can't write it down. We can't write how we want to destroy her, etc., etc. Something else interesting that they said is that on August 9th, there was another story coming out and it was circulating. And there was a screenshot of a post of another woman accusing Mr. Baldoni of additional misconduct and announced that she had directed Jennifer Abel directed Mr. Wallace to take action to suppress it, stating, "I'm assuming this is not true in the slightest. Either way, we flagged it to Jed and his team for more serious actions on the social sites." And then they're saying again that another story came out, another allegation surfaced regarding additional misconduct by Mr. Baldoni. As Ms. Abel stated, this girl is claiming that Justin invited her up to his hotel room years ago. Ms. Nathan advised Ms. Abel, "Let us chat to Jed as well on this." I never saw anything like that. But okay, so he invited a girl up to his hotel room years ago. Let it out. Let it out, Blake. It seems like they're just trying to grasp at straws to make Justin seem like a very, very bad guy. One incident. Do you know how many interviews were pulled of you? Oh my gosh. So pretty much it just goes into the rest of it as being which jurisdiction that the Wallace parties should be tried in. And he's trying to say Texas. They're trying to push for New York. They do often like to bring up Steve Sarowitz and his $100 million threat to ruin Miss Lively and her family. The film itself premiered in Manhattan, and it was at that premiere that Mr. Sarowitz announced that he was prepared to spend $100 million to ruin Miss Lively and her family's lives. Mr. Baldoni and Mr. Heath, as officers of Wayfair, also engaged with Jones' work, company with his principal place of business in New York, as engagement that initiated the retaliation campaign at issue. On the day of the film's release, Miss Nathan communicated with her sister, a journalist at the New York Post and contributor at Page Six, to shape her sister's coverage of Miss Lively in the Post. Miss Sarah Nathan continued to correspond with Miss Abel and Miss Nathan, even exchanging drafts of a story pushing the Wayfair party's narrative about Miss Lively's role in editing the film. Yeah, 'cause you did. You took over the film. I mean, sometimes your own actions have consequences, Yeah, that's pretty much it. I highlighted some other parts, like this part, if you want to read it. It's basically just saying that, he was saying it would be a financial burden. Jed Wallace was saying it would be a financial burden to keep traveling to and from New York. And they're saying, well, he comes to New York for leisure as recently as December of 2024. So it's not going to disrupt anything. It's not going to be a financial burden. We only need him from one day, and it will be a single trip to testify at trial. So there you have it. That's pretty much it. I don't think anybody's going to get dismissed. I think if anyone does have a good claim to get dismissed, it would be the New York Times. And I'm still thinking that they probably will not. I'm hoping anyway that they don't, because I want to see that paper trail. I want to see who redacted the text messages. I want to see the thousands of pages of text that they went through. And where they got their information. Was it directly pulled from the CRD complaint that Blake leaked to them? However, or was it, given to them already? Like who was cherry picking the text, and where did this story come from? Ryan Reynolds, I do not think is going to be dismissed in this claim. Neither is Blake Lively. But also to that point, I really don't think Jed Wallace will be dismissed either, because he was hired to his extent. I mean, yes, he made a statement saying that he did not do any of the things that Blake is claiming. And I mean, to a point, like, she does have the text, yes, that she got from Stephanie motherfucking Jones, gave them to Leslie Sloan, but is it enough to actually prove? I don't know. That's why they need discovery. That's why no one should get dismissed, That's all for now that's happened on the case, at least today. Yeah, it's kind of crazy. I cannot stress this enough, that if you are being harassed, if there is misconduct happening in your place of employment, you need to report it. You need to officially report it. You need to have those reports. You need to prove that you, one, felt unsafe. It needs to be subjective and objective in nature, and that you do need to have, it sucks because when this happens, unfortunately, when it gets bad enough to where it does change your employment, you need to be able to prove that you did follow the proper protocols in reporting. You need to have evidence of such reports, and it is scary because you think all of these people are going to have your back. You think, you have the proof. Here it is. This is wrong, right? We all know right from wrong. We all know sexual misconduct, unwarranted behavior, harassment. But if you can't prove it, it sucks. It's just like, all I can say is that if it is happening, report it as many times as it's happening, and keep all of those documents. Okay. It's so vital. Yes. Is it scary reporting it? Yes. Is it scary to stand up and say, what is happening? Yes. But I'm telling you to protect yourself at any means necessary. And if you need to get out of that place to protect yourself, do it. Thanks for the thumbs up. Okay, let's have some fun. First of all, and then, who's ready for Handmaid's Tale, the final season coming out in just a few days? I am so psyched. I will definitely be talking about that. I am so excited for this final season, but we're going to end on a good note. I am picking a card from the Listen Bitch card deck. We're going to just pick a card here and see what it says. Don't hold back the tears. Let them flow like a freaking faucet. Sometimes you just got to cry it out. I had a really good cry on Monday. I was so filled with so many emotions. I can't even describe to you what I was going through. It was just felt like this huge, heavy weight that had been on me. I just felt lifted from, and I cried and I cried and I cried. And sometimes you just got to let it out. You just got to release it from your body. Don't hold back. Let it out, because the more you hold it in, the more you hold all of that in your body, it's going to store in your body, and you need to let it out however you need to let it out. And if that's through a good cry, get the tissues and cry it out, okay? Okay. Well, I missed y'all. Thank you so much for being here. What just happened? Oh, I really appreciate you. And until next time, yeah, have the best day. Love ya. Bye.